Uh, Good afternoon, everyone, or shall I say, COVID-free afternoon, everyone. So I'm Nilo Divina. It will be my pleasure to walk you through the highlights of Revised Corporation. Let's start. First slide, please. Okay, first let's take a look at the historical background of the Revised Corporation Code. It was approved by Congress on February 20, 2019. It's a very meaningful date for me because it coincided with my birthday. So I was born February 20. So Congress approved the Revised Corporation Code on the same birthday and became effective February 23, 2019 upon publication in two newspapers of general circulation, Manila Bulletin and Business Mirror. Now, the law promotes ease of doing business. So let's talk about the basic features or characteristics of the Revised Corporation Code. It promotes ease of doing business. That's why you have provisions on one-person corporation that allows persons to put up corporate entities and yet limited in liability. So one person putting up a corporation, but limited liability insofar as that its contribution to the corporation is concerned. And then you have the rule on perpetual existence. So there's no need to keep on renewing the term of the corporation. So unless you forget, so there's no need to extend the term of the corporation. So corporation shall exist until the board of directors and stockholders decide to end it. And then, of course, you also have the provision regarding dispensing with the requirements for subscription and payment upon incorporation. As you all know, under the old corporation code, when you incorporate, you have to subscribe to at least 25% of the authorized capital stock and pay 1/4 or 25% of the subscription. That is not true anymore. You can put up a corporation without being bothered how much will be your subscription and paid up capital. It's only when you increase your capital stock that you have to comply with a 25% subscription and payment requirement. And then it also adopted best practices on good corporate governance. That's why the Revised Corporation Code requires that the notice of the meeting, the agenda of the stockholders meeting must contain certain information, all in the interest of promoting transparency. And third, it afforded greater protection to minority stockholders. In what sense? It widened the list of documents and books that the corporation must keep in its principal office for inspection of stockholders. And then it afforded likewise remedies, additional remedies to a stockholder in case he's denied the right of inspection. And now, as under the old code, before the present Revised Corporation Code, you only have two remedies in case your right of inspection is denied or enacted upon by the corporation. You can file a criminal complaint for violation of right of inspection. You can file a petition to inspect corporate books under the rules on inter-corporate controversy. Under the RCC, you have a third remedy. You can report to the SEC the inaction or denial of the corporation. And within 5 days from that report, the SEC must conduct summary investigation and order the corporation to allow you to inspect and examine the books of the corporation. And then fourth, it codified internationally accepted practices and norms on conducting business. That's why you have the use of technology. You can send notices of meetings electronically, and you can participate electronically or in absentia based on guidelines to be issued by the SEC. And lastly, it strengthened the powers of the SEC so that it can exercise effective supervision and jurisdiction over all corporations. Later on, we'll discuss that the RCC contains acts that are considered criminal in nature. Under the old code, there was only one offense, that is violation of right of inspection. Under the RCC, you have so many acts that will constitute criminal offenses. So let's take a look now at the provisions one by one. Because of the limited time, so for these are highlights of the revised corporation code. The revisions contained here that I will discuss more or less account for 90% of the entire provisions, but these are the most important revisions or features rather of the revised corporation code. Let's start with section 7 on founder shares. Now, just to refresh your memory, what are founder shares? These are shares that are classified as such in the articles of incorporation and given certain rights and privileges. If that privilege consists of the right to vote or be voted as directors, it's effective for a period of 5 years from incorporation. It used to be 5 years from approval of the SEC, now 5 years from incorporation. What does it mean? If the founder shares will be included as an amendment to the articles of incorporation, then the 5-year period is reckoned not from the amendment, but incorporation of the corporation. Unlike before, 5 years from approval of the SEC. Now, also under the RCC on founder shares, the RCC made very clear that founder shares shall not be used to circumvent the rules and laws on anti-dumping and the law related to foreign investment. In what sense? Now, you know that founders of or holders of founder shares can be voted as directors regardless of the number of their shares in the corporation. So that's the right granted to them. So no matter how insignificant their shares may be, they're entitled to be voted as directors for a period of 5 years. Okay. Now, let's say that the corporation is a public utility. And under the Constitution, as you know, 60% of the capital of the public utility must be owned by Filipinos. It's partly nationalized activities. Let's say there are 15 directors, or let's make 10 directors. And foreigners own 40% of the public utility corporation. That means that they can be represented in the board up to 40% of 10 directors. They're entitled to 4. Because the right to participate, the right to be elected as directors is in proportion to their shareholdings in the corporation. So let's say they have 40% of the equity of the public utility. So they can get 4 board seats. What if 2 foreigners have founder shares? Can those 2 foreigners get themselves elected as directors on top of the 40% that will be voted to 4 or vote for directors? Not allowed, because it will circumvent or violate the anti-dumping law in the Foreign Investment Act. Now, second also, we said that if the privilege granted to holders of founder shares is the right to vote or be voted as directors is good only for a period of 5 years, right? From incorporation. What about this one? Let's say the articles of incorporation provides that for every 1 share, the holder of the founder shares gets 10 votes. 1 share, 10 votes. Is that subject to the 5-year limitation under the RCC? And the SEC said no, because the only right that is subject to the 5-year period or limitation is the right to vote or be voted as directors. All other rights and privileges are not subject to any 5-year restriction. It depends on the term provided in the articles of the corporation. One more. Let's say the holders of the founder shares are given the right to receive dividends ahead of the preferred shareholders. And it does not contain any period. So can they get dividends then ahead of the preferred shares and common shares holders? And the answer is yes. Because to repeat, the 5-year limit only applies to the right to vote, be voted as director of the corporation. Next slide, please. Let's move on to section 10. Now, if you ask me what are the standout provisions of the revised corporation code, the most standout provisions, I would say 2. The rule on perpetual existence, and second, 1-person corporation. Under section 10, let's talk about number and qualifications of incorporators. Can you make it bigger, please? Make it bigger. Uh, smaller. Okay, that's good. Under the old corporation code, as you know, only natural persons are allowed to be incorporators. Not less than 5, not more than 15 incorporators. And natural persons. Okay. RCC remove the qualifications of natural person. Residency requirement. Minimum number of 5. No more. So even a corporation now or a partnership can be an incorporator. One person can be an incorporator. That's why you have one person corporation. Okay. Now, what if the incorporator is a partnership? So how will the partnership be an incorporator of a corporation? Of course, there ought to be approval from the partners to authorizing the investment in that corporation and designating who will be the representative or nominee of the partnership in the corporation. What about corporation? Same. The corporation must adopt a resolution by at least majority of the entire board and stockholders owning at least 2/3 of the outstanding capital stock, authorizing the investment and designating the person who will act as incorporator or a nominee of the incorporator corporation. Next slide, please. Okay, stop there. All right. Now, you know that the first incorporators are usually directors of the corporation, right? Okay. If an incorporator is a corporation, how can it perform the functions of a director? Is it not that only natural persons can participate in discussion, deliberations? So how can a juridical person like a corporation be an incorporator, say a director of the corporation? Okay, so should the nominee of the corporation, incorporator / director be a stockholder or member likewise of the corporation? Before the RCC, Supreme Court said in the case of Lim versus Moldex, the nominee of the corporation cannot qualify as a director unless he is also a stockholder of the corporation. And a member, the nominee of the corporation cannot be trustee of a non-stock corporation unless he is also a member of the non-stock corporation. What about under RCC? Is it necessary that the nominee of the corporation be a member or stockholder likewise of the corporation? Is he qualified to be elected as director? And the SEC said no. So the corporation as incorporator can be represented obviously by a natural person designated by the board. That natural person would be the one to participate in discussion, acting as nominee of the corporation as incorporator. He's not the director. It is the corporation, but through the natural person nominee of the corporation. Therefore, that nominee is not qualified to be elected as director unless he also owns one share of stock in his name in the books of the corporation. Next, please. Okay, I have discussed that. Next. Okay, next, stop there. Other than a one-person corporation, can a corporation, I have been asked this question many times, because the number of incorporators was taken out as a qualification for incorporators. Can you have incorporators less than 5? Less than 5. You have rules on one-person corporation, right? So can you have a corporation with 2? Yes, of course. Because don't have a minimum anymore. But it's not good to have 2. How do you break the tie? So dapat add number, right? So can you have 3? Yes. Except if the law requires certain number of incorporators and directors like banks. Banks and general banking law must have not less than 5, not more than 15 incorporators and directors. Except in case of merger, they can have 21 directors. And banks are not allowed to organize as a one-person corporation. Okay, let's now move on to Section 11 on corporate term. As you know, corporations organized under the revised corporation code shall have perpetual existence unless the articles provide otherwise. So don't think that corporations organized under the RCC automatically have perpetual existence. No, you have the option as a fixed term or perpetual existence. But if it is silent, you have perpetual existence. What about corporations organized prior to the effectivity of the revised corporation code? What happens to them? And this is the rule. They are deemed extended. So automatically they have perpetual existence. So there's automatic conversion from term to perpetual existence without having to amend the articles of incorporation. So no need to amend the articles, no need to call a stockholders meeting, get 2/3 of the standing capital stock, and board meeting, get majority of the board to approve the extension. No, it's deemed extended unless the stockholders, by a vote of majority of the standing capital stock, elect to retain their term as prescribed in articles of incorporation and makes it known to the SEC. But if they don't do anything, it's deemed extended. Automatic conversion, as I said, from term to perpetual existence. Okay, question. What about the rights of stockholders? Rights of stockholders. They're not in favor of perpetual existence. They can exercise their appraisal right. And this is my opinion. This is what I think. Because there is automatic conversion from term to perpetual existence, anytime a stockholder may demand the payment of the fair value of his shares. It is when the stockholders elect to retain the term that the stockholders not in favor are entitled to exercise their appraisal right. So if the stockholders don't do anything, it's deemed extended. A stockholder not in favor may exercise his appraisal right. Demand the payment of the fair value of his shares. Just to refresh your memory, under Section 80 of the Corporation Code, there are certain acts by which you can exercise your appraisal right. And appraisal right, again to refresh our memory, is the right of the stockholder to demand the payment of the fair value of his shares after dissenting against a proposed corporate act in the cases specified by law. All right. So there has to be a stockholders meeting, right? And you will dissent or vote against the proposed corporate act under Section 80. But under Section 11, because the term is deemed extended, if the corporation does not do anything, then anytime the stockholder can demand the payment of the fair value of his shares. As I said, it's when the stockholders elect to retain their term that the stockholders are entitled to exercise their appraisal right. Now, another question. What about non-stock corporation? It's deemed extended, right? Deemed extended. Are they entitled to exercise their appraisal right in non-stock corporation? And the answer is no, because there is no appraisal right in non-stock corporation. Now, why do I say that there's appraisal right in non-stock corporation? Number one, the right of the members of a non-stock corporation to the assets of the corporation can be exercised only upon dissolution of the corporation, and only to the extent that their distributive rights are defined in the articles of the corporation. So when you return the members their contribution, you're violating the features of a non-stock corporation. The assets can be given to them only upon dissolution, and only to the extent that the rights are defined in the articles of incorporation. Second reason, take a look at Section 15 on amendment to the articles of incorporation. It says there's a appraisal right, right? But that sentence on appraisal right refers only to stock corporation, not to non-stock corporation. And third, on perpetual existence, it says the stockholders are entitled to exercise the prejudice to exercise appraisal right by the stockholders, not by the members of a non-stock corporation. So those are the reasons why there is no appraisal right in non-stock corporation. Okay, another amendment under Section 11, before, You can extend the term within, you can extend the term by board of approval of the board, stockholders approval likewise, but you have to do it not less than 5 years prior to original expiration. Now, under the RCC, 3 years. You can only extend 3 years before its actual expiration, original or subsequent expiry date. Next slide, please. Okay. Can you backtrack to section 11, please? Section 11. Section 11. Okay. More. Okay, next. Okay. Now, section, this item number 5 in our notes. If the term has expired. So, as I said, that you have two options. Either perpetual existence or one with a specific term. If the term expires under the old code, ipso facto, the corporation is dissolved. By ipso facto, meaning by virtue of that fact that the term expired, it is automatically dissolved. So no need for a co-warrant proceeding, no need to get approval of the stockholders and the board of directors. Ipso facto, it is expired. Under the RCC, they remove the ipso facto dissolved phrase. Why? Because the corporation is given the option to file a petition for revival of corporate existence. Okay, you can file a petition, as I said, for revival of corporate existence, and once approved by the SEC, so the corporation will be deemed revived, certificate of revival of existence will be issued by the SEC, giving the corporation perpetual existence unless the application for revival provides otherwise. Okay, therefore, if the term, the specific term in the articles of incorporation, and the term has expired, what are your remedies? Number one remedy, petition to revive the term of the corporation. To revive the corporation. Second, reincorporation. Let me explain. The first one is revival of corporate existence. But if you file a petition for revival of existence, you're subject to liabilities, fines and penalties. So whatever the liabilities the corporation had to pay, let's say non-filing of general information sheet, non-filing of financial statements, no? So you compute, you have to pay this obligation before you can get your revival of corporate existence. The other option is you may reincorporate. You can put up a corporation by the same name, the same purpose, same incorporators. All right. Now, what happens to the properties of the dissolved corporation? Are they transferred automatically to the new corporation? Well, the answer is no, right? Because the corporation is dissolved, it's defunct. The assets could have been moved to the new corporation, obviously, unless you have liquidation procedure. So how will the assets now of the defunct corporation be moved to the new corporation? The Supreme Court said in Chuk Cabio versus IAC 163 SCRA, the stockholders of the defunct corporation can assign the right to these properties as their contribution to the new corporation. So that's how they get moved to the new corporation. So do your math. Which one is cheaper for you? The petition to revive existence, you compute the penalties and the fines, or do you just put up a new corporation? Because if you put up a new corporation, if you reincorporate, there's liquidation, and based on an arrangement between SEC and BAR, you have to pay the taxes as a result of the liquidation. Because there will be conveyance of assets to the stockholder, you have to pay the corresponding taxes. So I say that if the corporation has no major assets, right, you're better off, no? Of course, just pre-incorporating. Or if there are no assets, you're better off pre-incorporating. You only pay filing fee. But if the corporation major assets, so many assets, you're better off petition for revival because you're not subject, obviously, to income tax, no? When you don't anyway dissolve the corporation, and you simply ask the SEC to revive it, then you pay the corresponding penalties and subject to liabilities that I mentioned a while. Okay. Next. Now, let's go on to Section 12. Section 12 is a minimum capital stock. As I said a while ago, the RCC dispense with minimum subscription and paid-up requirement upon incorporation, except as provided by special law. So for a private corporation governed by special law, as I said, you are not subject to 25% subscription and 20% payment requirement. It's when you increase your capital stock that you're subject to subscription of 25% of the increase, and you have to pay 20% of the increased capital stock. Okay. Section 13 on articles of incorporation. First point, the articles of incorporation may provide for arbitration agreement. So what is significance of having arbitration agreement in the articles of incorporation? Now, as you know, dispute between or among stockholders, among themselves, that is, or stockholders corporation, subject to the rules of intercorporate controversy, right? You have to file the complaint in the RTC of the city where the principal office is located. If there's an arbitration agreement in the articles of incorporation, any recourse to the court for intercorporate dispute is premature or will be premature unless you have exhausted the arbitration procedure spelled out in the articles of incorporation. So it's one layer, right, that you have to comply with before you can seek court intervention. If you go to court without exhausting arbitration procedure, the cause of action is premature, will lead to its dismissal. And then second, the articles of incorporation or amendment can be in electronic form. Now, those of you who are in practice know that even before the RCC, a filing of the articles has been done electronically. But the RCC crystallized it. It made it a part of a statute that you can submit your articles in electronic form. Now, third, also very important, the articles of incorporation must contain an undertaking to change the corporate name upon receipt, right, upon receipt of the notice from the SEC. If it turns out after incorporation that the corporate name approved by the SEC is not distinguishable from a name reserved or registered for the use of another corporation, or the name as approved by the SEC is contrary to law or rules and regulations of the SEC. Estoppel doesn't rise against the SEC. Now, you, the practitioners, when you apply for incorporation, you all know the first thing you do is to verify if your proposed corporate name is acceptable, approved by the SEC. So they have a database of corporate names, right? And your proposed corporate name must be distinguishable from other corporate names. Used to be, must not be identical or similar with existing registered or reserved corporate name. Now the magic word is distinguishable from a corporate name reserved or registered for the use of another person. So going back to what I said, the articles must contain an undertaking to change the corporate name in the event that after approval by the SEC, it turns out it's not distinguishable from a name registered or reserved for the use of another person. Let me cite an example. One of our clients, My Health Corporation, it owns many clinics in Manila. They have one in Mega Mall, in Shangri-La Festival Mall. They also have one in Cebu and Davao. Anyway, we helped put up the corporation. The name is My Health Corporation. After a few years of operations became profitable, another group, they organized a corporation. It's My Dot Health Corporation. My Dot Health. Ours, My Health. The other one is My Dot Health Corporation. So to make it techy, My Dot Health. So the only distinction is the dot, My Dot Health.com. So when the client told us that there is this corporation with the same name, My Dot Health, no, they asked our opinion on what we should do to stop that corporation from adopting or using My Dot Health because it competes with our business, our client's business. So what did this remedy? Should we file a petition for co-warranto against that corporation? Should we file a complaint against that corporation? No. We only file a petition with the SEC to direct that corporation to change its corporate name because its name is identical with the name of our client. Our client acquired a prior right over the corporate name because it registered it ahead of everybody else. So the subsequent user, of course, has no right to it. So we just filed a petition to compel the corporation to change corporate name. And the SEC acted on our petition favorably. On the strength of the undertaking by every applicant for incorporation at the time to change the corporate name if it is not similar, or if it is similar or identical with another corporate name. Now that affidavit is now part of the articles of incorporation. The template articles of incorporation includes the language on the undertaking to change the corporate name. Okay, 4, I think I have discussed that. Next, please. Okay, stop there. Number 5, so as I said, there's no need to, remember when you incorporate, you have the affidavit, the treasurer, he must state under oath that 25% of the authorized capital stock have been subscribed and 20% has been paid up in cash or property received by the corporation. So no need for treasurer affidavit in that regard. So there will be certification on the amount of subscription payment, but treasurer affidavit, as we all know before, is no longer part of the requirements. Next, please. Okay, on corporate name, Section 17. So there are detailed guidelines and more requirements for a corporate name. So many guidelines were added, and the SEC now has the power summarily to order the corporation to cease and desist from using corporate name. We did not observe the guidelines approved by the SEC. If the corporation refuses, there will be corresponding criminal, civil, and administrative liability and sanctions. All right. And now, as I said, the primary basis now for allowing corporate name is it's not distinguishable, or it is distinguishable from another corporate name. It used to be, it should not be identical or confusing similar with another corporate name. Now that the keyword is distinguishable from other corporate name. Now let's take a look at the guidelines. So the SEC issued circular on the guidelines on corporate, recently issued. Let's take a look. There are many, but I will just choose what I think are the most interesting ones. The first, this is not known to many, no? The corporate name shall contain the word corporation or incorporated or the abbreviation. Okay, I've mentioned this to my students. When Equitable and PCI Bank merged, so for the quandary, one of the many questions that had to be resolved, what would be the name of the surviving corporation? Surviving corporation was Equitable Bank, but at that time Equitable was smaller compared to PCI Bank, but Surviving Bank is Equitable, so it had to be Equitable, and then add PCI to Equitable, became Equitable PCI Bank until it was merged with Banco de Oro. So we prepared the articles of incorporation, the plan of merger, articles of merger. The plan of merger, of course, specifies the name of the surviving corporation. It says Equitable PCI Bank. Right? I submitted the documents to the SEC. After a few days, Director Benny Cataran, good friend of mine, called me up. At that time, he was director for company monitoring and registration department. called me up. I mean, Neil, there's a problem with your papers. What problem? You did not include the word corporation or incorporated as part of Equitable PCI Bank. Oh my God, I said, oh, no. So what do I do? So at the back of my mind, I was thinking, because as you know, if you have to amend the plan of merger, you have to go back to your board and stockholders of both corporations in meetings called separately for a purpose. You have to get board approval, majority of the board of both constituent corporations, and stockholders approvals, again, of both corporations in meetings called separately for the purpose. And just to amend the name to include incorporated, the corporation is very embarrassing. So, you know, good thing that Benny is a good friend of mine. He now works for us, by the way, one of our consultants for corporation law. Said, okay, Nilo, ganda lang gawin natin. Padala ko sa iyo yung mga papers, ha? Ilagay mo na lang ink, dagdag mo lang yung INC, intercalate mo yung INC, Equitable PCI Bank Inc., handwritten na lang, and then authenticate with the full customary signature. So I did. I intercalated the word INC with my full customary signature, returned to the SEC approved. So nobody knows that except my students and those who attend my lectures. My Equitable PCI Bank, Banco de Oro, of course, do not know those details. Okay, also, if you're a one-person corporation, you have to add OPC. You're a foundation, you have to add the word foundation. Scroll down, down. Let's just choose the interesting ones. Okay, go ahead. Okay, number 4. This is very interesting. Can the corporation have a corporate name at the same time a business or trade name? Like a corporation, ABC Corporation, doing business and trade name style of, let's say, so-and-so. It's allowed by the SEC. So your corporate name can have a business or trade name at the same time, as long as it's in the articles, of course, of incorporation. Next. Okay, number 12. Okay, there you go. Now, this one is very interesting. I have to point it out because this is different from jurisprudence. In what sense? Under jurisprudence, the case of Indian Chamber of Commerce of the Philippines and Filipino Indian Chamber of Commerce, tamang difference. Isa, Indian Chamber of Commerce in the Philippines. Isa naman, Filipino Indian Chamber of Commerce. Pero parehong Filipino Indians, no? Engaged in business in the Philippines. The president is a good friend of mine, Rex Toriani, one of our clients, likewise. Anyway, so sabi ng Supreme Court sa case na yan, you can adopt the name of a defunct corporation 3 years after its dissolution. Okay, so 3 years after dissolution. But during the liquidation period, you cannot adopt that name of the defunct corporation without the approval of the last stockholders owning at least majority of the outstanding government stock. So during 3-year period of liquidation, get the approval of the last stockholders owning majority of the outstanding government stock. After 3 years, no need to get approval, right? So the SEC rules just came out recently, 5 years. So you cannot use for 5 years. This is different from jurisprudence. Jurisprudence is 3, but this one is 5. Because you have to follow the SEC because it's a circular that they issued. So you cannot adopt the name of a defunct corporation within 5 years after its dissolution. During the 5-year period, get the approval of stockholders owning this majority of the outstanding government stock. Next. Okay, now this one, point 15. The reservation notice of availability of name. So halimbawa, nagpa-reserve ka ng pangalan. So sabi nag-return ng verification slip, approved ng SEC. Yan ba'y approval na to use the name automatically? No? Well, hindi. Dahil the SEC later on can ask you to change the corporate name if it turns out that it is not distinguishable from an existing corporate name. So for the purpose of incorporation, that will do. But the SEC reserves all the time the authority to order you to change it if it turns out later on that it's not distinguishable from a name registered reserved for the use of another person. Okay, point 16. What if the SEC examiner denies your proposed corporate name? What is your remedy? For resolved by the CMRD, and then decision of the CMRD appealable to the M-Bank, to the Office of the General Counsel. Now, number 17, it says here, based on the circular of the SEC, you can either have an affidavit to change the corporate name as part of the documents you have to submit to the SEC when you incorporate, or it's part of the undertaking is part of the articles of incorporation. Now, I find this unnecessary. Why? Because your template articles of incorporation, section 14, contains the undertaking to change the corporate name. So there's no need for an affidavit to change the corporate name if it's part anyway of the articles of incorporation. Next, please. Okay, next. Okay. Here, what are the remedies available to incorporation against that authorized use of the corporate name? Somebody adopts or using the corporate name. Number one, file a petition with the SEC to compel the corporation to change its corporate name because it's not distinguishable from a name registered or reserved for the use of another person. Remember the case of Lyceum? Lyceum of the Philippines, tough. And there are many lyceums all over the country. Latest count 28. You have Liceo de Cagayan, Liceo San Pablo, Liceo Pangasinan, Liceo Cabuyao, no? There are many of them. And Lyceum of the Philippines, the one at top, would like to, well, basically ask SEC to direct those schools to change or drop the name Lyceum as part of the school or corporate name. And what was the remedy pursued by Lyceum? It never filed an action in court for co-warrant or what. It just filed a petition with the SEC to direct those schools and corporations to drop the name Lyceum. That was the remedy chosen. Of course, they did not win. Supreme Court said Lyceum is generic, cannot be appropriated by any person or institution. But that's the remedy that you choose or that you avail of. Petition with the SEC to change direct the corporation to change corporate name. Please backtrack, Sarah. Okay. On the remedies. All right. So first remedy, file a petition with the SEC. Second remedy, file a complaint against an authorized use of the corporate name under 159 of the RCC. There's a penalty. There's monetary fine against an authorized use of the corporate name. One of the criminal offenses under the revised corporation code. And third, if the corporate name is used as a trade name, you can sue for infringement of trade name. Now, as you know, in the case of Coffee Partners versus San Francisco Coffee 2010 decision, Supreme Court said trade name need not be registered with the intellectual property, with the IP, Intellectual Property Office. Unlike trademark that will be registered with the IPO, trade name need not be registered with the IPO. So in case of an authorized use of a trade name, you can sue for trade name infringement. Now, where do you register a trade name? DTI if you're a sole proprietorship, and SEC if you're a corporation. So if a corporate name is also a trade name, as I said, you can sue also for infringement of trade name. Next. Okay, this is very interesting case. I have to add this. Are Lyceum and De La Salle generic words that cannot be appropriated? What do you think? So they have different rulings. Supreme Court said Lyceum is generic word for school or education institution or facility for learning. It cannot be appropriated. What about La Salle? You have De La Salle, owned by the La Salle brothers, and you have De La Salle Montessori, no, in somewhere in the north. Okay, ang argument doon sa north, kasi nag-complain De La Salle sa TAF, no. Ang argument ng De La Salle Montessori sa north, Sabi niya, pareho lang yun. Yung Lyceum nga, sabi niya, to be appropriated. De La Salle is a French word for classroom. So no one can appropriate De La Salle. And Supreme Court is wrong because De La Salle is not generic. It is arbitrary. So it's possible, whimsical and arbitrary. Arbitrary marks can be appropriated and registered. Like Papa, no? Papa for ketchup, it is arbitrary. Now, why is it arbitrary? Sabi ng Supreme Court, ano ba connection ng classroom, no, sa education institution at saka brand of service, right? I mean, you need to have creativity for you to link, no, the word room with education institution. So in that sense, it is arbitrary and can be appropriated. Next. Okay. Section 25, 21. Effects of non-use of corporate charter. Okay, as you all know, under the old code, you have 2 years to organize, right? Under the new RCC, 5 years to organize and commence business. If you don't organize and commence within 5 years, deem revoked. Certificate of Corporation deemed revoked, you lead to dissolution of the corporation. Now, what if you commence business, you organize, you commence business, and suddenly you stop? So if you're not in operation for a continuous period of 5 years, you can be declared after notice and hearing in a delinquent status. So it's not automatic. So it's like this. So if you don't organize and commence business within 5 years, deemed revoked. Right? Now, the other way around, you start business, but you became you stop operations continuously for a period of 5 years, not deemed revoked. Why? Because the SEC, after notice hearing, can only may place you in delinquent status. And if you're placed on delinquent status, you have 2 years to resume operations and comply with the requirements of the SEC. If you don't resume operations and comply with the requirements of the SEC, then that's the time that you will be dissolved. It will lead to the revocation of the corporate franchise. Okay, there's this case where is a corporation considered, or SEC opinion, the formal organized commence business. So those who are putting up corporations, keep telling their clients. Next slide, please, Sarah. So dapat ito yung gawin nyo. Sabi ng SEC, you have to adopt your bylaws. The board must elect the officers. The board should register the corporate name, business name of the TTI. Register yourself the BIR, SSS, and establish an office and start your business operation. So these things you have to do so that you're considered to have organized and commenced business. Okay, I have taken it up. Section 22. Zoom on to 22. On board of directors and trustees, the term of trustee, as you know, modified for a period not exceeding 3 years. For directors, the term is still 1 year. As you see later, they remove the batching of trustees for non-stock operation. There is no residency requirement for members of the board. The RCC requires the election of independent directors. And you have to be a stockholder to be elected as independent director of a stock operation, but you don't have to be a member of a non-stock operation to be elected as independent trustee under Section 91 of the revised corporation code. So for stock operation, the independent director must be a stockholder. For a non-stock operation, the independent trustee need to be a member of the corporation. Okay, also, the RCC enumerated the corporations that are required to have independent directors. So who are they? So those required to have independent directors, basically, number one, public companies. Public companies. When are you a public company? If your shares are traded in the stock exchange, right? Second, if your asset is at least 50 million pesos. and 200 stockholders, each stockholder. Okay, it's so hot here. Sorry, it's not coronavirus, all right? It's just so hot here. So whether a public company, if your shares are traded in the stock exchange, listed in the stock exchange, or even though not listed in the stock exchange, you have assets of at least 50 million pesos with 200 stockholders minimum, and each stockholder owning 100 shares each. So 50 million assets, at least 200 stockholders, each stockholder owning 100 shares each, then you are a public company. So what you do is you don't have to be a public company, and you're subject to the requirement of having independent director. Get only 199 stockholders para hindi ka public company. Who else are corporations that are vested in public interest? Financial intermediaries like banks, passive banks, non-stock and loan association, pawn shops, printing companies, those engaged in money service, trusts, and insurance companies. And other corporations considered vested in public interest are determined by the SEC. Okay, question. What if you have 5 directors? 5 directors. The RCC says 20%, right? You have 5. So how many are required to have? 1 or 2? 1 or 2. Because for bank, under general banking law, they should have 20% of number of directors, but not less than 2. Now, I would say for banks, those cover special laws, it has to be not less than 20%, but not less than 2. Okay, now this is something very interesting. I was asked this question so many times. So how do you vote if you have independent directors? You're required to have independent directors. Let's say 10 directors of the corporation, 2 are required to be independent directors. So how do you vote? How many votes can you cast to determine who are your regular directors and independent directors? And the SEC issued an opinion on segregate casting of votes for regular directors and independent directors. What do we mean by segregate casting of votes for regular and independent directors? Okay. Now, as you know, independent directors must have qualifications not enjoyed by nominees for regular directors. Apart from their shareholdings and fees, they're not part of management, not subject to any circumstance that may interfere with the exercise of their judgment as director of the company. Okay, that's why if you're a counsel of the corporation, you're going to be independent director. If you're a controlling stockholder, you're going to be independent director. If related to the controlling stockholder, you're going to be independent director. If you're counsel, advisor, trustee, you're going to be independent director. All right. Now let's say you have 10. How would you choose now who are regular, who are independent? And this is what the SEC said. A stockholder can cast as many votes as he wants based on the shares of stock in his name, multiplied by the number of directors to be elected, inclusive of independent directors. So for example, you have 1,000 votes or 1,000 shares. You have 10 directors, 8 regular to independent. If you have 1,000 shares, 10 directors to be elected, you have 10,000 votes, right? Those 10,000 votes can be cast in favor of one nominee. You can accumulate all of your votes for one nominee for regular or one nominee for independent, or you can just use your votes for regular directors or only among independent directors, or you can distribute your votes as you please among regular and independent directors, as long as it doesn't exceed the stocks in your name multiplied by the number of directors to be elected. Okay. And based on this opinion, the top 8 vote getters among the nominees for regular directors are elected as regular directors. And the top 2 nominees among the nominees for of independent directors may be less than the votes of the 9th and 10th nominee for regular directors. That has been affirmed by the SEC. On requirement of citizenship, as you know, so there's a requirement to be a Filipino, to be a director of a corporation. Foreigners can be elected to the board of a corporation, except those engaged in nationalized activity with a party wholly nationalized. If it is wholly nationalized, foreigners, no, they cannot be elected to the board. If it's partly nationalized, like public utility, mining, exploration of natural resources, they can own up to 40% of the capital of those corporations. Then they can be represented to the board to the extent of their actual foreign equity. Okay, let's move on to election of directors. All right. The right of a stockholder to nominate a director is subject to the rights of the holders of the founder shares. Now, this is very clear. No? So, the right of a stockholder to nominate a director subject to the rights of the holders of the founder shares. Why? As I said a while ago, if you're holders of founder shares, you have the right to be voted as directors regardless of your shareholdings in the corporation. Now, those of you in the practice, you know that there's a minimum number of shares to be assured of a board, right? I mean, if you don't have the shares and votes, you cannot get a seat. But for holders of founder shares, regardless of their shareholdings, they get elected as directors. So if we have 5 holders of founder shares, 15 to be elected, it means that only 10 are up for grabs. The 5 are seated in favor of the holders of the founder shares. Now, point number 2, regarding presence during stockholders meeting, what are the modes of presence under the old corporation code? You only have 2, right? In person or by proxy, right? Person by proxy. Under the RCC, you can be present electronically. You can be present in absentia. So how can you be present in absentia? Well, the law allows it. But based on guidelines to be issued by the SEC. As of today, there are no guidelines yet. So the SEC said, 2019 opinion, this provision is not self-executory. You need to have guidelines from the SEC on electronic presence, meaning voting electronically or in absentia, right? There ought to be guidelines from the SEC. So they have to be in the bylaws of the corporation based on guidelines issued by the SEC. As of today, there are no guidelines yet. But for those that are vested in public interest, the law says very clearly, even though it's not in the bylaws, they have the right to electronic presence or voting. So for those that are vested in public interest, it need not be in the bylaws. So they can avail of the prerogative or remedy under the RCC. Next, please. Next. Next slide, Sarah. Okay, now it's a very interesting question. Ito yung mga course, may problema ganito. Okay, mga law students yan. Paano kung hindi magkaroon ng quorum? Ang hirap makakuha ng quorum sa stockholders meeting, no? Or members meeting. Nakatatlong notice ka na, walang umate, walang sumisipot, walang interested. Okay, ano nga mangyayari dyan? So as you know, the term of a director is 1 year, right? Until successor elected and qualified. Sa pag walang meeting, anong gagawin? So Section 33 introduce the concept of emergency quorum. What do I mean? Okay, you have your annual stockholders meeting. For whatever reason, it did not push through. So under the RCC, I'm sorry, you have to report to the SEC within 30 days from date of the election why the meeting did not take place. And the report must contain a new schedule to elect the directors of the corporation. And the schedule of the meeting should not be later than 60 days from the scheduled date. Now, what happens if on the new schedule, wala pa rin quorum. Wala pa rin dumating. Hindi pa rin majority of standing government staff. Under this rule, Section 25, no? You now have the emergency quorum. So whoever are present in that meeting, so whether stock or non-stock, no, the attendance in that meeting will constitute a quorum, even though it's less than majority of the standing capital stock or less than majority of number of members for non-stock operation. You all know that quorum for stock operation is majority of the standing capital stock, right? For non-stock, majority of the members of the corporation. So for this emergency quorum purpose or concept, the attendance can be less than majority of the standing capital stock or majority of the members, and you have a quorum. They can transact business. Okay, next. Section 24 on corporate officers. Okay, treasurer, of course, required to be a resident. Now, those of you, I understand that some are practitioners, in attendance are practitioners. You know that under previous SEC regulations, they keep on flip-flopping or changing the regulation, diba? Sometimes they would say treasurer must be a resident, sometimes not going to be a resident. So once and for all, let's decide. So sabi ng RCC, the treasurer must be a resident of the corporation. Resident. And then it requires the appointment of compliance officer. A compliance officer for those corporation vested with public interest. That's why, you know, they have seminars now on compliance officer, because their positions are now required by law for those that are vested with public interest. Okay, what are the qualifications of the president, secretary, and treasurer? Next slide. So the president must be a director, and of course, as such, should be a stockholder. You cannot be a director unless you're a stockholder. He must not hold concurrently the position of secretary and treasurer. So you can be both president and secretary, president and treasurer at the same time, unless special law allows you. So there's not a qualification unless special law allows you. But if there's special law, then you can be both president and secretary, president and treasurer. Now, can you be both secretary and treasurer? Yes, it's possible. Now, can you be both chairman and president at the same time? Diba? Kung lima lang kayo, siyempre, ikaw pa rin chairman president, di ba? Pero pag you're governed with the code of good corporate governance by the SEC for publicly listed companies, that is, the chairman must be separate from the CEO or president position. But for a non-public listed company, the chairman can be president. Huh? So ang hindi lang pwede, presidente, secretary, presidente, treasurer. Chairman, president allowed except for listed companies. Okay, question. What about president and compliance officer? Can they be held by the same person concurrently? If you read the law, silent, di ba? Ang sinasabi lang, hindi ka pwede secretary, presidente, treasurer, presidente. But I say that the president cannot be a compliance officer. Because a compliance officer is a full-time job. So based on regulations issued by BSP, by the SEC, a compliance officer is a full-time job. And he ensures that all the rules, all the laws are complied with, including acts of the president. So how can you be both president and compliance officer? Who will check you if you're the president and compliance officer at the same time? So I say, even though it's silent, the president cannot be the compliance officer at the same time. Okay, next slide, please. Okay, this is a very interesting question. It's an SEC opinion, no? So, can the bylaws designate 3 presidents, no? 3 presidents. But you know, we don't have to answer the obvious. So SEC said no. President is a very important position. Malilito ang mga tao kung 3 presidente mo, no? Dapat isa lang ang presidente ng corporation. You can have many vice presidents. Banco de Oro has about 2,000 plus vice presidents, no? But there can only be 1 president. Next. Okay, now this one is very interesting. Is the CORSEC of the corporation required to be a lawyer? Well, you check the corporation code. Meron ba sinasabing kailangan abogado? Yung corporate secretary? Wala. Sinasabi lang citizen and resident, right? Except except if the corporation is covered by the revised Code of Corporate Governance. So like public companies, listed companies, if the CORSEC is also the compliance officer, it's preferred that he is a lawyer. Next. Okay, I think I have covered this a while ago. Next, please. Okay, time check, 3:30. Okay, removal of directors or trustees. So this is a new provision. So the SEC is given the authority motu proprio or upon verified complaint. No? But of course, after due notice and hearing, in line with the requirements of due process, to order the removal of a director who was elected despite disqualification. Despite disqualification. Okay. Now, my only take about this, merong notice and hearing, di ba? Eh, by the time matapos ang hearing na yan, tapos yung term ng director. No? So, SEC can order removal if he is not qualified, no? Elected but not qualified, he can be removed by the SEC. But given the requirement of notice and hearing, he may outlast his term, the 1-year term. True or not? True. But subject to penal sanction. It's one of those acts considered criminal under the RCC. If you elect a director knowing that he's not qualified. Next, let's take a look now. Earlier we talked about emergency quorum. Let's talk about emergency board. So this is under Section 28 of the revised Corporation Code. What's the concept of emergency board? So these are the requisites. First, the remaining directors cannot have a quorum. So the vacancy prevents them from having a quorum. Let's say 15. Eh yung 8 nagka-COVID. Huwag naman po sana, example lang, nagka-COVID. No? So 7 na lang. So they cannot have a quorum, di ba? Okay. Now, if you only have 7, under the old code, what is your only solution? You have to call a special stockholders meeting to fill up those vacancies, right? Because the board can fill up the vacancies only if the remaining directors constitute a quorum. But if there's no quorum, only stockholders can fill up the vacancy, right? Okay. Now, what if the urgent matters be attended to by the corporation? What will happen now? So the RCC solved the problem by having an emergency board. So emergency action is required to prevent grave, substantial, irreparable loss or damage to the corporation. And then the remaining directors must elect from whom? From whom? Among the officers of the corporation. They cannot elect from non-officers, only from the officers of the corporation. And there has to be unanimous vote from all the remaining directors, trustees. So those officers now become members of the board. Now they now have a quorum, right? So they can now act on matters requiring urgent attention of the board. But their term is coterminous with the emergency action that needed to be addressed. Next. On compensation of directors, the RCC clarified that directors should not participate in determination of their per diem allowance. Now, per diem allowance is not part of compensation. Because compensation, as you know, for directors as such, can only be given if authorized by the bylaws, right? Or approved by the stockholders owning majority of the standing capital stock. They cannot be approved by the board only. Okay? Compensation, like profit share, bonuses, allowances to directors, or housing plan, car plan, they have to be in the bylaws or approved by stockholders owning majority of the standing capital stock. What about per diem? Per diem allowance is not compensation. Therefore, it does not need stockholders approval or bylaws provision, right? Under the RCC, however, the board cannot participate in determination of their per diem allowance. What does it mean? So if they have to pass a resolution, let's say they will increase the per diem, no? From 10,000 to 50,000 a month for every attendance. It will be prospective in application. It will not cover them. So the safe bet, therefore, is to have it in the bylaws so that the board can say we do not have a hand in the determination of our per diem allowance. If it's not in the bylaws, the board may fix it, but prospective in application. Now, you've heard, my students have heard this, the per diem allowance of San Miguel, PLDT, no, it's not peanuts, about 250,000 for every board meeting. And then on top of that, you can attend committees. If you're a board meeting, sorry, if you're a board director, I'm sorry, you will be member also of various committees. There are many committees in the board, as you know, legal oversight, executive committee, compensation committee, audit committee, legal oversight committee, risk management committee, so forth and so on. If you're a director, for sure you'll be a member of a committee. When I was in the board of UCPB, I was in 3 committees. Despite my busy schedule, I was in 3 committees. Others had 4, 5, 7 committees. Now do your math. If you are a director of San Miguel, you attend board meeting, you get 50,000. All right, and then you have 3 committees, 200,000 per committee meeting. So 3 times 200, 600 plus 250, 80,000 just for 1 month. Just for 1 month. So attend board and committee meetings of the likes of San Miguel and PLDT. It's allowed because the only requirement for per diem is reasonable. Because reasonable depends, of course, on the stature of the person, the operations income of the corporation. Okay, now I would like to bring your attention to one item under Section 39. Under the old code, it says the aggregate annual compensation of directors as such directors must not exceed 10% of the net income of the corporation before income tax of the preceding year. So that was clear. The aggregate annual compensation of directors as such directors not to exceed 10% of the net income before income tax of the preceding year. Okay. Under the revised corporation code, they removed the phrase as such directors. What is the implication? Now, in the case of Western Institute of Technology Versailles, Supreme Court said the rule against payment of compensation to directors only applies for payment of compensation for director services. So for director services, it's only allowed if it's in the bylaws or approved by stockholders or majority of the standing capital stock. But if a director is also the vice president or the president, he can be paid as president, and his payment as president is not subject to bylaws provision or approval of stockholders, right? The board or the compensation committee can fix the president's salary, right? So the president's salary is not part of the 10% cap under the old code. It does not include non-director services. The RCC removed that phrase as such director. Therefore, the compensation of directors for both director and non-director services should not exceed 10% of the net income corporation or income tax of the preceding year. Next. Section 31, it expands the cooperative self-dealing provision. What does it mean? You all know under section, it was 32 then of the old code, if a corporation contracts with its director, officer, it has to be, it's subject to the following requirements: the presence of director not necessary for a quorum, his vote not needed to approve the corporate act, the vote, the transaction will be fair, reasonable under the circumstances. You can dispense with the first 2 elements. The presence is not necessary for a quorum, vote not needed to approve the corporate act, as long as ratified by stockholders owning 2/3, right, of the standing capital stock. And the contract is fair, reasonable under the circumstances. The RCC expanded the self-dealing provision to include spouses and relatives up to 4th degree of consanguinity affinity of directors and officers of the corporation. Okay, so we were engaged by a big bank. Our law firm was engaged by a big bank to handle a case for them, significant case for them. I was in the board of the bank at that time. So if the bank would contract my services, the self-dealing, right? So I should have been present in that meeting. My vote should not be needed in that meeting. It has to be fairly reasonable under the circumstances. In that case, of course, I waive my fees, so it's reasonable under the circumstances. Now, RCC, if the contract is between that bank, let's say, and relatives, spouse relatives of mine, then subject to the same requirements. All right. Next. On corporate powers, so corporations are now allowed to enter into partnership and joint venture agreement. Old code did not allow corporations to enter into partnership. They can enter joint ventures or backward sanitary wares, but now it's part of the powers of the corporation. It can enter into partnership and joint venture agreement. And then second, very interesting, domestic corporations can now donate in favor of any political party or candidate. The prohibition is only against foreign corporation, but domestic corporations, they removed the prohibition on making donations in aid of partisan political activity. Somebody asked me why. Why do you think, sir, that the RC removed it? I say, it's being done anyway. We might as well legitimize it, right? So that's what I said, no? For jokingly. Anyway, so it's now part of the powers of the corporation. On power to increase and decrease capital stock, there's a period of 6 months. You cannot delay it. 6 months from approval of the board, stockholders, you have to file the application with the SEC. Otherwise, it's pasok, unless you ask for extension. To repeat, if you increase the capital stock of the corporation, you have to file the application within 6 months from board and stockholders approval. Otherwise, paso na yun, unless you get extension from the SEC. Okay, moving on to section 39. For sale and other disposition of assets. Well, you all know the rule. If the sale amounts to all or substantially all the corporate assets, has to be approved by the board, majority vote at least, stockholders bet is 2/3 of the standing capital stock, under the RCC now subject to the approval of the Philippine Competition Commission. Now, the SEC issued an opinion for publicly listed companies. So when is a sale considered sale of all, substantially all? Scroll down. So pag listed companies, ito ang rule. Okay. If the sale amounts to at least 51% of the assets computed based on its total assets as shown in its latest audited financial statement. Okay. So for non-listed companies, anong rule? Diba ang rule is, if after the sale, the corporation cannot attain the purpose of its incorporation, then it amounts to a sale of all or substantially all of the corporate assets requiring board approval and stockholders approval. Okay, all or substantially all. Of publicly listed companies, ang rule lang is at least 51% of the assets of the corporation are being disposed of based on total assets in as shown its latest audited financial statement. And also, speaking of the Philippine Competition Commission, they issued a new regulation. Those of you who are familiar, you have the two tests, right? Size of the person test and size of the transaction test. What does it mean? Size, scroll down, there you go. Stop there. March 1, 2019, you have a new norm. So the tests are now 6 billion for size of person and, no, sorry, they increase it 6 billion for size of person, 2.4 for size of transaction. So size of person, meaning the assets of the acquiring or acquired entity, 6 billion, and size of transaction, 2.4 billion at least. If these two concur, you have to notify the PCC. Otherwise, transaction is void. Next. On content of bylaws, I already said a while ago, the bylaws now may contain provisions on electronic sending of notice, modes of attendance of stockholders electronically or personal proxy. And it can also provide for maximum number of representation for independent director. So how many corporations are you allowed to be independent director? You can be in the bylaws because you can be independent director forever, right? So the moment you're independent director of one corporation, you will lose your independence and you will no longer be independent director. So this can be provided in the bylaws also. Okay, on point, backtrack. On contents. Item number 1. Now this one I find very interesting. Under the old code, the bylaws must be submitted prior to incorporation or within 1 month, right, from incorporation. The RCC removed the provision on submission of bylaw within 1 month from incorporation, and yet retained the authority of the corporation to adopt the bylaws after incorporation. Now, why do I find this interesting? If we check the website of the SEC on the documents you have to submit before they will act on your application for incorporation, ano yung document na kailangan isama mo doon? Bylaws. Bylaws. So, hindi pwede mangyayari sa practice, no? Yung bylaws mo after incorporation because the SEC will require the bylaws prior to incorporation. Okay, next. For meetings, so as you know, the bylaws is silent any day after April. It should be any day in April, right? Now, any day after April 15. What's significance of this? Why do they make it any day after April 15? Bakit di any day in April? Kasi pag any day in April, it can be April 1, April Fool's Day, right? No, just kidding. So that in time for the submission of the financial statements with the SEC. Okay, one thing about meeting, by the way, I thought that this should be addressed in the revised corporation, but it's not there, so the jurisprudence is still true. Therefore, the case of Rico Ford was the DCAN 2016. Supreme Court said, if the bylaws specifies the exact dates and time of the annual stockholders meeting, like let's say, 3rd Monday of August, 12:30 p.m., and if that day is a holiday, the next business day is not a holiday. So if the bylaw specifies the exact date and time of your annual regular stockholder meeting, the lack of notice will not vitiate the legality of the meeting nor affect all of the items taken up in that meeting. So even though you're not notified 21 days before the annual stockholders meeting, if the bylaws has a date anyway, the lack of notice will not invalidate the meeting. Okay, I sit here. Where should the meeting be held? Where should the meeting be held? Under the old code, as you know, it has to be in the city where the principal office is located, and as far as practical, the principal officer, right? It's now the other way around under the RCC. The rule now is it has to be in the principal office of the corporation, and if not practicable, that's the only time you can have it in the city or municipality where the principal office is located. Next. As I said during the regular meeting of backtrack. As I said during the regular meeting of stockholders, the board must endeavor to present to the stockholders and members minutes of meeting, no? Certain matters that have to be made known to the stockholders for transparency. Well, you can just take a look. It's coded anyway. But you know, just one interesting anecdote. So I can devote my remaining time for the other topics. Just one interesting anecdote. What about attorney's fees? Should the corporation report to the stockholders fees it paid to its lawyers? You know, let me share with you an anecdote. There was one case where one of our adverse parties requested our client, stockholder, no? But belonging to the competing camp, a stockholder asking the corset and the president of our client the amount of our fees, legal fees. And I had a feeling rather, that that stockholder will file a petition or an action for derivative suit. I had a feeling that probably he will question the amount of fee being paid to us, no? Probably will say that he is exorbitant, so on and so on. For there is no exorbitant, excessive fees, so it's all a matter of determination with the client and the law firm. But anyway, so that was my feeling. So what did we do? We filed a petition for declaratory relief with RTC Makati for the court to determine whether or not our fees can be subject of inspection by a stockholder. We argued that it is outside of inspection because it's something confidential, only between the client and our firm. And the RTC of Makati ruled that fees, legal fees are confidential, outside right of inspection. What about under the RCC? The law says even non-audit fees must be reported to your stockholders. Now, the law doesn't say you report how much you pay to a specific law firm. But the RCC says you have to report even non-audit fees to your stockholders. So what happened to us that I think is no longer valid now, given the requirement under the RCC. Next. 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 Okay, respond to 61, consideration for stocks. The RCC added shares of stock in other corporation as allowable form consideration and any other form of consideration that is generally acceptable. I was asked this question. Can you pay your subscription by way of cryptocurrency? Cryptocurrency, Bitcoin. And I say, well, if it becomes a generally accepted consideration, yes, with the law, the RC allows it now. The law does not say cryptocurrency, but it says generally acceptable form consideration is now valid. So if it becomes generally acceptable later on, then it can be accepted as payment for subscription. And then second, stockholders can now participate in determination of the value of property as consideration for issuance of shares. Di ba before, pag ang consideration property, it must be valued by the board, right? Fairly valued by the board, subject to approval of the board and the SEC. Under the RCC, the valuation determined by the stockholders or the board and finally approved by the SEC. On 73, as I said, the RCC expanded the list of documents and books that the corporation must keep, no? And fail to keep these documents in the principal office is a crime. It's a crime. Okay, what else is a crime under 73? Violation of right of inspection. Okay. Now, somebody asked me this question. The RCC removed the penalty of imprisonment. Unlike the old code, imprisonment or fine or both the option of the court. Under the RCC, just a fine, 10, 20,000, up to 400,000 maximum for violation of right of inspection. Therefore, is it correct to say that the RCC decriminalized violation of right of inspection? And the answer is no. It's still a crime, except that the penalty is simply monetary fine, no longer imprisonment. As you know, under the revised penal code, you can have a crime even though the penalty is only fine, right? If afflictive, corrective, so forth and so on. And there are many laws out there, so many laws, Safe Space Act, use of belt, helmet, where the penalty is only fine. So just because the penalty is a fine, that imprisonment doesn't mean that it's not a criminal offense. Next, please. Next. No, back. Back, 73 ulit. 73, Sarah, 73. Diba, balik pa. Okay, there you go. So we have mentioned it did not decriminalize. So what are the remedies now of a stockholder? Next slide. Next, diba? Okay. What are the remedies now of a stockholder if the corporation doesn't act on your demand for inspection? You now have three remedies Number one, remedy, you can report the denial or inaction to the SEC. And within 5 days from issuing the order, the SEC must conduct a summary investigation and order the inspection and production of the requested records. Second, you may file a criminal complaint for violation of right of inspection under 73 and 161. And third, you can file a petition to inspect corporate records under Rule 7 of the Rules of Intercorporate Controversy. Next. No, backtrack mo na. Backtrack. Okay, there you go. Stop. Okay, on point number backtrack. Sorry. There you go. There. Okay. All right. Number 3, point. Pakibaba ng konti. Anyway, so yeah, there you go. Stop. Okay. It's also a new provision. Any stockholder who shall abuse his right of inspection shall be liable. Okay. Without prejudice, provisions of intellectual property and data privacy Act were subject to the rules on data privacy and the IP. So if you abuse your right of inspection, you can be charged likewise. You have this right, but if you abuse it, you can be held liable. And also, this one is worth expounding. The RCC prohibits right of inspection for stockholders who represent an interest adverse to the corporation. To refresh your memory, in the case of Gokwe versus SEC 89 SCRA, if a person is in the board of a competing corporation or a stockholder of a competing corporation or represents any interest adverse to the corporation, he will be disqualified by the corporation, right? So the bylaws may provide as ground for disqualification conflict of interest. And that provision is held to be valid in the case of Gokwe versus SEC because sound corporate policies dictate that the person cannot be in the board of two competing corporations. His duty of loyalty may be compromised because he may appropriate important information and leak it out to his other corporation. That's the gist of Gokwe. Now, the RCC goes one step further. Stockholders who are from competing interests can be denied right of inspection. So they have no right of inspection based on the spirit of Gokwe versus SEC. You know, I mentioned this to some of my students. You know, Gokwe, of course, you know, is now in heaven, builder of an empire. So at one time he had a handshake, no, to buy PLDT. He had a handshake with Salim in Hong Kong to buy PLDT and Smart, but he wanted to have access to the records of PLDT Smart. He wanted to conduct due diligence to determine the exact worth and value of the two companies, but the CEO at that time, Manny Pangilinan, prevented access to the corporate records. So according to him, John Gokwe at that time owned Gitel, a telecom company that competes with PLDT Smart, and he may be given access to information that can be detrimental to the interests of PLDT Smart. So basically, he was blocked by Manny Pangilinan. The transaction did not push through. So John Gokwe put up Sun, as you know, and made very profitable, and it ate up the market of PLDT Smart, such that at one point PLDT had to buy it at a very good price for the Gokwe Group. And they're still also in the board of Smart. Now, under this RCC, any stockholder of a competing corporation cannot be given access to the books and records of the company. Not just qualified to be elected as director, but not being given access to the books and records of the corporation. Okay. Also remember this another anecdote. We're counsel for the biggest steel manufacturing company in the Philippines, Steel Asia. At that time, there were 3 stockholders of Steel Asia, the Go family, the Yao family, also our clients, and then the Tata Steel, the biggest Indian manufacturing company, one of the biggest in the world, and the biggest, of course, in India. So they own 40% of the company. They wanted to inspect the records of the company. And if we deny them right of inspection, they may sue our board and corporate secretary criminally. At the time, there was criminal, I mean, the penalty was imprisonment. If we allow them access, they may get the records, right? And use the same against our corporation. And they also engage the same business. What did we do? We filed a petition for declaratory relief with RTC and asked the RTC to determine if the request for inspection is made in good faith or bad faith, because they also own a similar business. And we got RTC judgment saying that they cannot have access to customer records of customer, names of clients, no, suppliers, because these are proprietary information. RTC was affirmed, we were affirmed by the CA, and then it stopped there, did not appeal anymore to the Supreme Court. And now, there's a recent case, Supreme Court said, no, Terla Investment versus ULO. Trade secrets are outside right of inspection. So trade secrets outside of inspection. So these items cannot be exposed, are given to competing interests and their stockholders. Okay, next, please. Plan of merger or consolidation, just very minor revision, but important in what sense? The articles of merger should now include the carrying amounts and fair values of the assets and liabilities of the constituent corporations. What do you mean by carrying amounts and fair value of the assets? It's like this. When you do a merger, you have the surviving and the absorbed corporation, right? After the merger is approved by the SEC, the stockholders of the absorbed corporation become stockholders of the surviving corporation, right? Okay. Because there will only be one corporation at the end of the day. So the surviving corporation accommodating both the stockholders of the surviving and stockholders of the absorbed corporation. And the question is, for every one share of stock of the stockholder of the absorbed corporation, how many shares of the surviving corporation, right? So they will be swapped. The shares of the defunct or absorbed will be swapped with shares of the surviving corporation. Okay. Based on an exchange and swap ratio approved by the board, right? Now, the RSCC says the articles of merger must indicate the carrying amounts and fair values of the assets and liabilities. So the stockholders can determine if the swap ratio is fair. If it's not fair, they may vote against the merger and exercise their operation. Next, please. Okay, konti na lang. On purposes of non-stock operation, well, basically, they removed the, remember before, merong batching or staggered term, right, ng trustees, no? 1/3, 1 year, yung initial trustees, 1/3, 1 year, the other 1/3, 2 years, the remaining 1/3, 3 years, every year there'll be election, right? So that 1/3 gets removed every year. Not anymore. They removed the batching of or staggered terms of trustees, 3 years, and the other was provided by the bylaws of the corporation. On dissolution, this is mostly procedural. Basically, they reduced the requirements for voluntary dissolution where creditors are affected from 2/3, it reduced to majority of the outstanding capital stock. All right, and then they introduced a new feature about withdrawing a request for dissolution or withdrawing a petition for dissolution. So even though you have petition for dissolution, so if no creditors are affected, it's called request for dissolution. If creditors will be affected, it's called petition for dissolution. Both requests or petition can be withdrawn by same number of directors and stockholders. Anyway. All right, item number 4. This is very, if you take a look at the provisions regarding shortening of corporate term, it says that if a term is shortened and that shortened term arrives, ipso facto, the corporation is dissolved, right? Earlier we said, if the term has expired, the corporation may file a petition for revival of corporate citizen, right? Now, if it is shortened term that expires, ipso facto, the corporation is dissolved. So, original term, Now automatic, because you can ask for petition for revival of corporate existence. But if it is expiration shorter term, ipso facto, corporation is dissolved. Okay, next. I think I'm already finished. Next. Next. Okay, backtrack. So these are new grounds for dissolution of the corporation. So you now have a separate provision on involuntary grounds. All right. Number one, of course, under Section 21, we discussed a while ago, if the corporation does not organize and commence business, certificate of incorporation deemed revoked, you lead to dissolution of the corporation. Second one, members, so non-operation, start business, but non-operation for 5 years, ground to revoke certificate of incorporation. Now, these are new. Receipt of a lawful order dissolving incorporation. What are good examples of this? So here, the SEC will dissolve because there is an order from a competent court dissolving the corporation. Example, de facto corporation. How dissolve a de facto corporation? Through a quo warranto proceeding, right? So if the court renders judgment in the quo warranto proceeding dissolving the corporation, that becomes your involuntary ground. Under FRIA, remember, under FRIA, if the order of liquidation is granted by the court, what's the consequence? Operation is dissolved, and liquidation should continue. And then finding with final judgment, corporation procured fraud or procured incorporation through fraud. Example would be corporation misrepresented the purpose of this incorporation, or in one case, the incorporation used fictitious names. So the incorporators used fictitious names. So there was fraud in procuring certificate of incorporation. There's a final judgment dissolving it, for cognizance, take cognizance of by the SEC. And something new, finding by final judgment that the corporation was created for the purpose of committing, concealing, or aiding securities violation, smuggling, tax evasion, money laundering, or graft and corrupt practices. Next. Or aided in the commission of these violations, or tolerated graft and corrupt practice acts or illegal acts by its director, trustees, and officers. Now, for these last three grounds I enumerated, smuggling, securities violation, graft and corruption, the SEC may file a petition to forfeit the assets of this corporation in favor of the national government, without prejudice, of course, to rights of innocent stockholders and employees for services rendered. Next. A few more minutes. Okay, how much time is it? Oops. Okay. Next, please. There are other grounds. Okay. Anyway, the enumeration is not exclusive. There are the grounds to dissolve the corporation under PD 902-A. So anyway, there are many. It all boils down to one thing: violation of any laws, rules, and regulations by the SEC is a ground to dissolve the corporation. Non-submission reports to the SEC, ground for dissolution of the corporation. Okay, just my last anecdote, just a few more slides and we should be done by 4:30. This refers to UST, our counsel for UST and University Hospital. Congratulations again to Kenneth Manuel, placed 6th in the bar. Artemas and Barrister, 18 of them. Congratulations again to all of you. And in this case of UST and USTHI, so UST Hospital Incorporated was organized for the purpose of managing the hospital of the university, to separate it from the university. So some officers of the hospital and some Dominican fathers put up in good faith this corporation to manage UST Hospital. But unfortunately, for them, there was an instruction from the master of the order to dissolve USTHI. So it got a loan to start the construction of a new hospital. But the loan was aborted, so the master of the order says revoke USTHI. And I was asked, what's the most expeditious way to revoke a corporation? I said, fathers, we can just shorten the term of the corporation. We shorten the term, and when the term expires, ipso facto, corporation is dissolved. Right? That's the fastest way. So they approved, and board resolutions, stock resolution passed. We got approvals to dissolve by shortening the corporate term. Unfortunately, we computed our taxes. They had to pay 8x amount, huge amount for tax clearances. So I was asked, is there any other way to dissolve the USTHI? So I had to tell them, Father, we can do a merger. We can merge USTHI with GST. UST as your surviving corporation. And I was asked whether or not merger is a mode of dissolution, because the instruction given to them for all the way from Rome is to dissolve USTHI. So they have to comply. Otherwise, it's a violation of the vow of obedience. So I was asked, is merger a mode of dissolution? I say, of course, Father, because in a merger, the absorbed corporation is dissolved. It ceases to exist. There's no liquidation, but under Section 79 now of the RCC, the absorbed corporation is dissolved. It ceases to exist. Right? So they approved the merger. But it takes time because you need to prepare long-form audits, so forth and so on, until a miracle happened. What was this miracle? We got a letter from the SEC that USTHI has not been submitting its reports and financial statements for the last 3 years. And unless it submits these reports, it will be dissolved by the SEC. Because I told you, right? Now, submission reports is a ground to dissolve the corporation. So I said, go ahead and dissolve USTHI. We got dissolved involuntarily. So when I told the fathers about this, I said, Father, it's a manna from heaven. It's a miracle. It's a miracle. And you know what makes it even more miraculous? In case of involuntary dissolution, no need for tax clearance. Pag voluntary dissolution, you need tax clearance, right? Pag involuntary, no need for tax clearance. So we got dissolved. We achieved the objective of USTHI in a manner which is different from the intended purpose of the regulation, right? Anyway, so non-submission reports, non-violation of any laws, administered as a ground to dissolve the corporation. Next, please. Few more slides. On corporate regulation, this is based on a case, the case of petition for assistance in liquidation, Royal Bank of Bukod Benguet versus BIR. So PDIC took over Royal Bank of Bukod Benguet to carry out this liquidation. Sabi ng BIR, you cannot dissolve liquidate the bank because it does not obtain tax clearance. You have to get tax clearance first before you can dissolve and liquidate the corporation. So PDIC filed a petition against BIR, arguing that when it comes to banks, so the rules on dissolution regulation of banks are different from the rules of liquidation for private corporations. And the Supreme Court affirmed, or the stand of PDIC, that when it comes to banks, they're governed by BSP Charter, General Banking Act. So they can be dissolved and liquidated without having to obtain tax clearance. Tax clearance only applies to private corporations. If the rule is otherwise, you will render illusory the power of BSP and PDIC to dissolve and liquidate a distressed bank, right? So if BIR has a claim, they can participate in liquidation proceeding, but not to prevent the dissolution and liquidation of the bank. That case now part of the revised corporation code. Next, please. On foreign corporation, well, anyway, this is all procedural. It's about increasing the amount of securities. You have to deposit securities with the SEC, basically to stand as a guarantee for claims being filed against a foreign corporation. The amount was increased. The value of securities increased from 100,000 to 500,000. And then the threshold amount to increase by 2% from 5 million to 2. Anyway, these are more procedural. Let's move on to the next slide because I don't have time. Okay, this one, as I told you, the RTC now, so the RCC penalizes certain acts on top of right of inspection. So there's, under the old code, there's only one crime, violation of right of inspection. Under the RCC, you have the following: unauthorized use of corporate name. Next. Appointing a director despite this disqualification. Next. Not keeping records or allow inspection of these records for your stockholder. Next. Willful certification or incomplete, inaccurate, misleading statement of reports. Next. Collusion with independent auditor. You cook the books of the corporation. Obtaining your certificate of incorporation through fraud. Fraudulent conduct of business. Acting as intermediaries for graft and corrupt practice act. Penalties. Engaging as intermediary for graft and corrupt practice act. Tolerating acts of corruption. Next. And then, kung meron nagsumbong sa korporasyon nyo, bineweltahan ng korporasyon, it's also crime. Okay, now stop there. Under Section 170 of the code, it says any other violation of this code punishable by a fine of X amount. Question. Does it mean then that any violation of the code will give rise to criminal liability? Let's enumerate. You did not pay the balance of your subscription. Are you liable criminally? You don't pay interest on subscription. Are you liable criminally? As a director, you breached your duty. You violated the doctrine of corporate opportunity. You seize an opportunity that belongs to the corporation. Are you liable criminally? Or foreign corporation transacting business without license. Is that a crime also? And the Supreme Court said, in the case of James E.N.T. versus Tolay Prevon, that these acts, while violative of the Corporation Code, are not criminal offenses. 2017 decision. Not criminal offenses. So therefore, I say this Section 170 that learn its lesson from that case of Tolay versus Prevon. So it is not enough basis to say that all violations of the code are criminal in nature. It's only a crime if the law says it's a crime. So there has to be a clear intent on the part of the legislature to criminalize the act, like the acts are enumerated, right? Enumerated by the RCC. Other than these acts, you can take the position based on Tolay Prevon case that they are not criminal offenses. Next. Next. Last slide, 2 more slides. Okay, I made this the last presentation, last slide. One person corporation. One person corporation. It's, as I said, one of the standout provisions of the RCC. What are the characteristics? Of course, single stockholder, obviously, right? Yeah, one person corporation. Don't say, by the way, one man corporation. That's very sexist. So one person corporation. Not required to have minimum authorized capital stock as provided by special law. No need to submit bylaws, obviously. But you have to indicate letters OPC. Your sole stockholder is also the president. Now, can he be the treasurer at the same time? He cannot be the treasurer. He's the president. He cannot be the corporate secretary, rather, of the corporation. Yes, next, please. Okay, back side, please. No. Okay. Okay, anyway, never mind. Sige, baba ng konti. Okay, I think what is important is this. The features you can take a look. But here's the important principle behind one person corporation. He is limited, his liability limited to subscription to the one person corporation. The same rule as any ordinary corporation. the liability of the stockholders is limited to subscription to the corporation. If you organize then a one-person corporation, your liability is limited to your subscription to that corporation. As long as you do the following. The assets of the one-person corporation and the assets, your assets must be independent. You can commingle these two assets. Otherwise, they lose a separate legal personality. Second, it must be adequately financed. Third, it should not be used or misused or abused for fraudulent end or purpose. So the same doctrine on piercing veil corporate fiction applies even to one-person corporation. So you cannot abuse the notion of separate legal personality for a fraudulent end. The moment you do so, then the personality of the stockholder becomes one with the one-person corporation. But for as long as the transaction is legitimate, then your liability as stockholder of that one-person corporation, as I said, limited to your subscription. Next, please. So how do you distinguish a sole proprietorship from a one-person corporation? Now, given now the rule on one-person corporation, it doesn't make sense anymore, right? To organize a sole proprietorship. Why? If you're a sole proprietorship, the sole proprietorship has no separate legal personality from the owner of the business, right? The assets of the sole proprietorship are the assets of the proprietor. The liabilities of the company, liabilities of the proprietor. Therefore, the liabilities of the proprietor can go beyond his contribution to the company, right? Pag sole proprietorship. Pag one-person corporation, limited to subscription to the corporation. Okay. Next, please. Let me pose this question to you. Can a person organize more than one person corporation? I remember acting as moderator. The IBP UP Law Center organized a conference at a time when there was no COVID yet. No, organized a conference. Different lawyers from different parts of the world came to the Philippines, and the topic assigned to me was about one-person corporation. We have speakers from People's Republic of China, from Malaysia, and we had the General Counsel of BSP. Because this is not in the RCC, I posed the question whether or not you can have a one-person. We can have more than one OPC. Let's say one OPC for laundry, one OPC for trading, one OPC for different business, so forth and so on. So you're liable only with respect to your subscription in each of the OPC. So according to General Counsel, so the RCC is silent. So we got the side of Malaysia. Malaysia says it's allowed. China says not allowed. So there is a tie. So the General Counsel is of the opinion now that you can have more than one OPC, as long as, of course, you use the same for legitimate purpose, not fraudulent ends. Next slide. Now, for a more comprehensive discussion of the RCC, check out the soon-to-be launched Question and Answers in the Revised Corporation Code by yours truly. It's about 520 pages, packed with jurisprudence, SEC opinions, circulars of the SEC, and of course, insights from yours truly. So thank you for listening. Jaro, can you please turn it off? I'm still on down. Jaro, Jero, okay, off. Jero, off mo daw. Jero Boy, nakapagpunta tayo. Jero.